Greetings to Prof. Dr. Nazura and Dr. Rahaida. We are from Firm 14 and our project paper is titled Challenges of Cap Rank Rule in Criminal Cases. Firm 14 members consist of myself, Nur Rehana, Evian C, Nur Ashifa Akila, Anila, Azriana Arisha, and Edwin Raj. A centuries-old idea acts as a beacon of fairness in the realms of legal ethics and the pursuit of justice, the cap rank rule. This rule was conceived as a core premise within the legal profession to provide equitable access to legal representation, transcending the nature of cases and clients. As cap rank rule is not applicable in Malaysia, this rule has been embodied into Rule 2 of the Legal Profession Practice and Etiquette Rules 1978 that embodies the essence of the cap rank rule, emphasizing and advocates and solicits the need to access every brief within their practice courts. The cap rank rule is more difficult in criminal cases due to moral and ethical issues, increased public security of the legal profession reputation, personal safety concern, emotional toll associated with serious criminal offences, complex legal issue, and the potential impact on victims. Hence why the authors chose criminal cases for the context of analyzing these challenges. This study uses a qualitative research approach to look into the difficulties related with the cap rank rule in criminal cases within the legal profession.
Moving on to literature review, John Floyd in his article entitled The Cap Rank Rule, Its Meaning and Purpose in the New Service Legal Market has stated that on the question as to whether this rule sets out any beneficial purpose, John Floyd has claimed that it may be pertinent to note that the limited applicability of cap rank rule is only relevant to a small part of legal practice market, which only focus on professional clients rather than being easily accessible to the public itself. Apart from that, Patrick O'Connor, an associate tenant from Doughty Street Chambers, also stated that the cap rank rule imposed severe limitation, which privilege is usually provided to non-criminal cases rather than criminal cases. He stated that realistically, the assigned barristers were never given instructions to prosecute in criminal cases and they would only be available to defend civil cases. Tony Franchise, a legal practitioner proficient in legal aid service, in his article has propounded that the court has its discretion to allocate criminal cases to those who are left unrepresented, particularly for grave offences of murder or manslaughter. This is also in line with what has been enshrined in the Constitution, where everyone has the right to be represented, particularly in criminal offences. Even in Malaysia, Akila Zulaika Zulkifli and Jason Yong Kok Yew has stated that the right of an accused to be represented in criminal cases was granted in our federal constitution. It is a duty of the lawyer to the court to represent their client at the best of its professional competency.
There are a few relevant rules relating to the cap rank rule. Firstly, the right to legal representation in both criminal and civil matters is guaranteed by Article 5 of the Federal Constitution. This means, for criminal cases, an arrested person is always entitled to his rights to appoint a lawyer. Secondly, it is the basis of Legal Profession Act 1976 where justice is upheld with the presence of the profession's duty to ensure equal access to legal representation for all individuals. For Legal Profession Practice and Ethics Rules 1978, it requires lawyers to offer advice or accept briefs in the court they practice, charging appropriate professional fees based on the case complexity and duration. And other than local rules, Principle 18 of the United Nations Basic Principles on the Role of Lawyers and 1998 report of the Special Rapporteur was the different view stating that lawyers should not be associated with the client's causes merely because they are fulfilling their professional duties.
Next is rule in ensuring access to justice. By law, it is set out by Section 602 Bar Standards Board's Code of Conduct, where all barristers are compelled to follow the cap rank rule that ensures legal presentation to all. Next, Article Subclause 3, Subclause C, European Convention on Human Rights, gives guarantee to clients for representation in court. It is stated that everyone charged with a criminal offence has right to defend himself through legal assistance of his own choosing. Next, Article 5 Subclause 3 of the Federal Constitution provides that where a person is arrested shall be allowed to consult and be defended by a legal practitioner of his choice. Next, legal presentation is also ensured to all, including the needy, as stated by Section 42 of the Legal Profession Act 1976, where it is stated that legal aid centres are required to provide legal representation services as part of a mandatory national service. Next, according to the case of Ramli bin Saleh, Inspector Yahya bin Hashim, 1973, client or arrestee are given the privilege to communicate with their representative who are lawyers or solicitors when they are held up in lockup, and this can be made provided that they are guarded or have any police officer inside.
Moving on to conflict between duties towards client and to the court. An advocate and solicitor does not only owe duty towards his client but also to the court and towards his profession. According to the case of Abdul Kadir, the court assumed that an advocate is the officer of the court. Thus, advocate must balance the duties owed to both the client and to the court to avoid conflict of interest. How to balance both duties? Firstly, advocates and solicitors should constantly remind themselves that their obligation to the court take precedence above the obligation to the clients, and advocates need to present their client's argument in an honest and sincere manner. And thirdly, the advocates has to decline to take a matter further in the event if the client coerces or threatens the advocate into acting unethically. There are several challenges that may arise from conflict between duties towards clients and to the court in the framework of cap rank rule in criminal cases. The first challenge is maintaining client confidentiality. This is because this may conflict with the requiring disclosure of information that is relevant to criminal cases, even if it goes against the duty of confidentiality. The second challenge is cap rank rule generally discourages advocates from withdrawing from a case once accepted. This happens in the case of withdrawing from criminal proceedings. The third challenge is criminal cases often demand specialized knowledge and experience due to their complexity. The cap rank rule may compel advocates to accept cases outside of their expertise.
Alright, moving on to the next slide, we'll talk on the comparison between the Malaysian rule and United Kingdom. Alright, this principle is actually laid out in the Rule 2 of Legal Professional Practice Ethics Rules, and which upheld the cap rank rule from the United Kingdom actually. And as opposed to the rule that compels all practicing advocate and solicitor in Malaysia, the rule in England only applies to the barrister. Hence, a barrister only receive an instruction from the professional client, which are appropriate according to the experience, seniority and field of practice. This is being laid out in their handbook, Rule C30 of the handbook, which they are to know the identity of the client, the nature of the case, in which may be formed to the character or reputation of the client. Alright, so moving on to the fee, we can see that issue of the fee, there is no standard amount that a barrister will or should charge to the client for. Barristers are allowed to set their own price for their service based on the effort and experience in handling their brief. This is similar to the position in Malaysia, as litigation fees are not subject to any specific rules. But nevertheless, the Bar Standard Board has introduced new rules which require all barristers to publish some information about chargeable fees and rates either on their website or in their copy format. Right? So this assists to potential client to understand the price and service provided by the barrister before rendering their service. Hence, I think Malaysia is still lack of this renowned practice, which clearly shows the lack of Malaysia experiencing the transparency in their fee. That's all from me. Thank you.
For this writing, we have identified key findings and provided some recommendations for enhancing the framework surrounding the cap rank rule in Malaysia. Firstly, we found that there is a limited clarity in the Legal Profession Act, in which there is a lack of explicit provisions outlining the rule, leading to interpretational challenges. And secondly, there are limited enforcement mechanisms, lack of awareness and education among legal practitioners and the public contributed to the non-compliance of rules. In addition, since the legal landscape in Malaysia is continually evolving, with the new challenges and complexities emerging, the cap rank rule must adapt to address these challenges effectively. Not to mention, there is a need to explore ways to enhance the rule to ensure that it considers factors such as gender, ethnicity, and socioeconomic status, promoting a more inclusive legal profession. We also provided some recommendations such as legislative amendments, strengthening the enforcement mechanisms, educational initiatives, adaptation to emerging legal fields, and inclusive application of the rule to strengthen the cap rank rule, ensuring its continued relevance and effectiveness in Malaysia's evolving legal landscape.
To conclude, while the cap rank rule confronts obstacles in criminal cases, addressing this issue requires a nuanced and adaptable approach. Legal systems should explore refining the rules application, assisting lawyers in managing conflict of interest, and acquiring specialized skills and communicating openly with the public. By carefully navigating these issues, the legal profession can preserve the values of the cap rank rule while providing competent representation in the complicated context of criminal defense.